Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. This is our last episode before Christmas, so Merry Christmas, everyone. We're recording this on Wednesday, December 20th, 2023. We have a couple guests coming up who are both my colleagues and both have some fantastic Fourth Amendment cases from the 10th Circuit and the 8th Circuit that we're going to dig our hands into. First, just a couple quick announcements. As you know, the Institute for Justice does all kinds of marvelous things, marvelous cases, fighting for liberty, fighting for justice. Unfortunately, they can't do that for free. So I'm going to make one more pitch before the end of the year that if you believe in what IJ believes in, would like to help us out, fund our litigation efforts and the many other things we do, such as the Center for Judicial Engagement and Short Circuit, you could go to ij.org/donate and then give to your heart's content before the end of the tax year. Also, please check out Bound by Oath. Season 3, Episode 2 is just about to drop. You can hear all kinds of mysteries solved by my colleague John Ross on our podcast documentary series. But here on our Short Circuit podcast series, we, in this last episode, right before Christmas, we don't have a Christmas special this year, but last year, you may remember, we had the 12 Days of Short Circuit Christmas, where we sang about all the circuits other than the Federal Circuit, which we really don't cover. And one of those singers is joining us today, Christie Hebert. Christie, welcome back.
Thanks, Anthony. You're reminding me of that. That was pretty fun last year.
What was your line?
I have no idea. I
can't remember. I remember your colleague down the hall, Tori. She had the five golden rings equivalent, which was 5 Judge Hos, I think, because each number was for a circuit. But I can't remember what yours was. It was very memorable, though.
Yeah, sure, super memorable. But I think you should do medley compositions of IJ singers again at some point.
There will be an excuse, and then all the audience that thinks it's cringe, they can pass it by. And for the couple who don't, you're welcome to listen. Someone that you should be listening to though is Evan Lisull. So Evan has been on before. He did a First Amendment case a while before. He's back here again with this Fourth Amendment case. And Evan, for those of you who don't know, I think his title is editor extraordinaire, because basically all he does all day is edit our writing, and he does an incredible job. He finds things that no one else has found wrong with your writing, or that not even wrong, but just could be better. And one thing I found, so Evan was one of very few people, Christie was actually another one, who helped with some proofing of my book. And Evan found that I think it was my first chapter, I had used the word harebrained. And so I always thought harebrained, I don't write the word very often, but I always thought harebrained was like someone has hair for brains. So HAIR, brain. Right. And then Evan found that's wrong. It's HARE.
As in a rabbit.
Like a rabbit brain?
Yeah.
Yeah, wow. And correct it. And no one else, like a lot of very smart people had read that chapter. Smarter than me, and Evan was the one who saved the day. So
yeah, although that one, you wonder if that doesn't change over time. There's a lot of those that Ryan Garner, the Don of legal writing, tracks, sort of phases as things evolve with usage. And I would not be very surprised if HAIR brained overtook HARE and 50 years time.
Now I have this image of Brian Gardner as like the godfather.
Oh yeah,
kind of figure.
Pinstripe suits, the whole nine. Yeah. Absolutely.
I mean, I think that's been true for a long time. Yeah, Brian Gardner is the godfather of legal writing. He was even, called, when I was in law school, which is a long time ago now. Our legal writing instructor, I think, first introduced me to his writing. So, Christie, you are going to introduce us to this fun case out of Oklahoma in the 10th Circuit, and it has to do with tow trucks and M16s. I mean, it sounds kind of like a, kind of an alt country kind of thing. But what's going on there?
Well, it is kind of an alt country interesting experience. This is United States versus Ramos, depending on how you're going to pronounce it, out of the 10th Circuit. And it has a lot of facts. It's fact intensive. So I'm going to try to just hit the high points here. It is in the kind of country vein, from a tiny town in Oklahoma, a town that appears to have less than 5,000 people in it. And that's an important context for in a minute. But the police in this town, late one night, were called out to a public disturbance at a convenience store. And when the single officer on patrol that night arrived at the convenience store just before midnight, he saw two dudes fighting in the parking lot. That officer quickly intervened and separated these two men. And here's how the Court of Appeals, the 10th Circuit, characterized what happened next. After the two combatants were separated, Mr. Ramos, and that's the defendant in this case, lightly slapped, quote unquote, the officer on the officer's right cheek and said, quote, "is fine," to the officer. The officer then arrested Ramos for assault and battery on a police officer. Now, the important context is this tiny town. It seems that Ramos and the police officer were former classmates. Probably went to high school together, is my guess. It seems that they knew each other well and they knew each other's families. And after the arrest, the question came up, what should the officer do with Ramos's vehicle, which happened to be a tow truck that was parked in the convenience store's parking lot. And just before midnight, 8 minutes after the officer arrived on the scene, that officer decided, I'm going to impound that tow truck because he had arrested Ramos. And that apparently was the officer's protocol. If he arrests someone, he impounds their vehicle. A equals B. And after the officer called for a tow truck to tow Ramos's tow truck, so tow truck, tow truck.
Tow truck squared.
Tow truck squared, the officer did an inventory of the items in Ramos's tow truck. And that's kind of standard practice when you tow a vehicle, impound a vehicle. You have to check what's inside to have a record of what was in the car or the vehicle so that, someone can't come back later and claim, I had $1 million in my truck and you absconded with it. And when inventorying the tow truck in this case, the officer found an M16, which the court classifies as a machine gun, an M16 behind the driver's seat. And in consequence, Mr. Ramos was charged with being a felon in possession of a machine gun and the corresponding ammunition. After he was charged, Ramos moved to suppress the ammunition and the gun, arguing that the impoundment, the seizure of his truck, violated the Fourth Amendment. And that motion to suppress is what we are here discussing today. Just kind of a quick overview of what happened in the courts. The district court denied the motion to suppress, said the evidence, the gun and the ammunition could come in. And that is kind of the whole kit and caboodle in this case when you're looking at a gun and the charge is you illegally had possession of a gun. The gun is the critical evidence. So the defendant in this case, Ramos, entered a conditional plea. That means that if the evidence could come in, he was pleading guilty. And the real question is whether it was proper for the evidence to come in at all. And the district court in this case concluded that there was no evidence, the record lacked evidence that the officer's decision to impound the vehicle was motivated by pretext. And by that, you just mean a desire to search the vehicle. He impounded the vehicle, the truck, just to search it. And then after the district court concluded that, the district court walked through the 10th Circuit's 5-factor test, which is used to determine if the impoundment is justified by non-pretextual community caretaking rationale. And a word about that rationale, that's just basically the Supreme Court and the 10th Circuit's recognition that police need to be able to impound a vehicle or cars for public safety or traffic concerns. You just don't want random vehicles sitting on public roadways, for example, police need to be able to tow those vehicles. Now, the 10th Circuit says impoundments are constitutional only if they are guided by, one, a standardized policy, and two, that legitimate caretaking rationale. And the 10th Circuit assesses whether there's a legitimate rationale by using the 5-factor test known as the Sanders factors. And looking at the 5-factor test in this case and the 10th Circuit's analysis, the 10th Circuit said the district court weighed those factors incorrectly. And I'll try to quickly walk through those 5 factors. The first factor is whether the vehicle was on public or private property. And here, the vehicle was in the parking lot of the convenience store. In the 10th Circuit, that said that that's private property. That's the end of the analysis. If the vehicle is on private property, the factor cuts against impoundment. You don't really consider anything else. And then the second factor is whether the owner of the property consented to the vehicle remaining there or asked for it to be towed. And here, the officer didn't ask the convenience store personnel, didn't even think to ask the convenience store personnel. Instead, the officer just assumed that because there was a sign saying something along the lines of violators, customer parking only, violators will be towed, that the convenience store would have wanted this vehicle, this tow truck, to be towed. And the 10th Circuit said, nope, officers, you can't guess. You can't guess based on context clues or other things whether the property owner would want the vehicle towed. You should ask and see if you can get consent to leave the vehicle. And the officer in this case didn't do that. The third factor is whether there are alternatives to impoundment. And in this case, Ramos asked the officer, can I call my mom? Can I call my mom to come get this truck? She lives 3 blocks away, and she'll come over and get it. And the arresting officer knew Mr. Ramos's mom, and he still said nope. Well, actually, he just ignored Mr. Ramos's request and decided he was going to impound the truck anyway. And the 10th Circuit kind of makes the point that the officer didn't even consider alternatives, that he doesn't have a duty to necessarily allow those alternatives to be executed or chosen, but he didn't even consider it.
He really wanted to tow this truck, it seems.
Because he wanted to tow this truck. Yes. And then the fourth factor is that the truck wasn't implicated in any crime. It wasn't part of the public disturbance that was in the parking lot. The truck had nothing to do with it. And then the fifth is whether the driver consented. And here, Mr. Ramos didn't consent. So those are the kind of the factors that the court walked through. And the court said, hey, all of these factors cut against impoundment. And seems like a pretty open and shut case. But I think the real big takeaway from this case is that the 10th Circuit is trying to really signal that the Sanders factors for the community caretaking rationale and whether you impound a vehicle are binary black and white factors. They're either satisfied or no, they're not. And the court is really trying to take out some of the discretion, I think, from those factors so that courts are getting out of the business of Monday morning quarterbacking for police officer decisions. And instead, officers will have more of a checklist to walk through on whether they can impound a vehicle or not. Private or public property, consent from the property owner, alternatives, vehicle part of a crime, and owner consent. They can just kind of walk through that checklist. And the final observation I'll make here is that I think the 10th Circuit is really trying to evaluate, is the community caretaking rationale something that actually has weight here? And is it enough to outweigh the individual's Fourth Amendment right to be free from unreasonable searches? A lot of times we see kind of in the Fourth Amendment context, a lot of discretion afforded to officers making decisions. And here you really see the 10th Circuit at least trying to give weight to the Fourth Amendment right.
So, Evan, have the cops ever searched your car when it's towed after an altercation?
No, I have not had the privilege of having my vehicle towed and subject to a administrative inventory search, which I'm very grateful for. I guess one thing, just to dwell on that public and private factor for a little bit, I was kind of taken aback by the officer's insistence that, we couldn't leave the car in the parking lot. One of the arguments was, well, you could have just left the car there overnight. You didn't need to tow it. Never mind the mom being able to get there even before the tow truck did, even though you never told her. But it's, oh, no, we're going to get sued. If something happens to this poor vehicle, in this town of 4,000 people, if one of the 3 tow trucks in town is broken into, they're going to come after us. Or the convenience store is going to come after us. And I've been scratching my head trying to envision, if something were to happen, how would that lawsuit work? I must be missing something, but to me, the cops would there's no established law. No, you've got no basis for, there's no taking here. I just could see a million defenses the government would bring up in this scenario where the tow truck's left overnight and then something, heaven forbid, should happen to it. I could see the government coming up with 14 different defenses as to why they're not responsible for that. And yeah, that seemed to be like a very grave concern. They sound more like an insurance carrier than a government in this scenario.
Yeah, I think there's a lot of lack of clarity on the police officer's side of, I'm just going to throw these things up and see what sticks in terms of my rationale to conduct the search. And, to be fair to this officer, he probably doesn't know how it works either.
Yeah.
And the police department doesn't want to be in the business of defending any kind of lawsuit. So they'll just say, I really want to search this truck because I think there might be something in it. So I'm going to come up with a bunch of different reasons. And, if there any validity to this potential liability thing, I don't want to be involved later. So we'll just say that's a good rationale too.
I mean, there's also something like, this is such a Larry McMurtry fact pattern. Like, that's what I was thinking, like, in the way, like, there's just like this small town. There's one point they're going through like the businesses. There's a radio station, a laundromat that closes at 10 p.m. I'm like, this is the most small town blown up dispute. So your reading is that you think the officer knew there was something in the back and he wanted that. Okay.
Yeah,
I don't know.
I think so. This is a guy who has like Mr. Ramos is a felon in a small town.
Yeah, that's true.
There's some insinuation that he'd been drinking, which is fine. Like the cheek pat
really
is fine.
Seems
to suggest to me that like probably had some alcohol in him.
Yeah.
So there's like some elements there for sure.
They all went to high school. They all went to high school together.
They all went to high school together.
Both of the guys in the altercation and the cop all knew each other.
We're talking
years
in federal prison, right?
Yeah.
For this offense?
That's
and
right.
This is about like some high school grudge, like boil. Like it just seems so picayune to lead to like, a pretty big sentence. As the other case we'll talk about. I mean, I think this is some serious time, right?
Yeah, it is some serious time. But, the other factor that I had to think about is this guy had a M16 just sitting behind his driver's seat. And so, there is some public safety concern that this potentially drunk guy has a M16 tucked behind his driver's seat. So, we do want the police to be able to kind of exercise those public safety concerns. And, as we'll see when we're going to talk about your case too, Evan, the motion to suppress does arise a lot in these gun cases.
Right.
Because it's the whole kit and caboodle, as I said in the beginning. And you're not seeing motions to suppress in other contexts because it doesn't A, matter as much, or B, if you're just a general Joe Schmo who has your Fourth Amendment rights, you might not go out and hire a lawyer to litigate your Fourth Amendment rights. I'll add this other piece. You are totally right that there's a lot of facts, and it seems like a small town dispute that are really kind of blew up. And the record here just has so much. It was 11:51 when the police officer arrives and 11:59 when the tow truck, and then the opinion kind of goes through the lighting in the area. The convenience store had some lights on, and surrounding businesses had some lights on, but it was still not well lit. And there's just so many facts. And so what you're really seeing is a whole trial on this motion to suppress. And I think the defense attorney in this case, I had to actually look her up. She's out of Colorado, she's the public defender out of Colorado and Wyoming, which made me like, wonder how she got assessed this case in Oklahoma.
Well, they're very busy in Oklahoma federal court these days with the fallout from the McGirt decision.
Yeah,
so
that's right.
I'm just speculating.
There's no more Oklahoma.
That's a good point.
That's probably part of it.
Probably why. And she did a really excellent job of building a record by what I would call matchstick facts to create a bigger picture.
One other matchstick fact that kind of maybe puts this in a little bit more perspective is they said that the tow truck was actually still running.
Yeah.
At the time. So, I could, I don't think this excuses the officer, but it shows you how in making these determinations, often it is very context dependent. So if it's still running, obviously you have the cop can't just leave the tow truck running, because then what if someone walks up and drive? Well, they probably would, be in trouble. Maybe they'd have excuses, but you're not going to detain the driver and then just leave it running, right? You're going to turn it off.
Well, the court here didn't give a lot of credibility to that fact, it seemed.
Yeah.
It seemed that, the government emphasized that fact apparently a lot in their brief, and it was said one time by the officer, I think, in his testimony below. And so the court here kind of gave that, I think, in a footnote, that fact, the back of the hand, like, we're not really sure if that was actually what was going on, or the officer just kind of said that the truck was running because he wasn't sure, or he said it last minute. So that fact seems here to not really be considered. And I think if it was in the record previously below, this truck was running, and I didn't want it to just leave it running in the middle of this parking lot overnight, that would have been kind of a bigger deal versus like a one-time mention.
Well, and you still, they could have called his mother.
Right. There's so many ways for this to de-escalate. It was just like kind of jumps out at me. Like, they obviously wanted to arrange for this to be towed. And maybe knowing there was a gun, but maybe he's just like, you know what, Ramos, I've had enough of you. I've had enough of your garbage. You hit me. I'm going to make you pay. You're going to have to go down to the lot, and you're going to have to pay whatever fee. We deal with that in some other cases. Who knows what fees they're slapping on for, impound and getting your vehicle out. You're going to pay for this one. Right. I'm going to get you this time. And then he does the inventory search, and geez, this is a little bit more than I, reckon I was going to get.
I mean, maybe he was hoping for some drugs or, whatever it is they usually find in these searches. And then, there's a machine, technically a machine gun, which is not just a felon. I mean, I haven't looked up the criminal statutes, and we were all talking about this before in the green room beforehand, but that's, unless you have a real special permit these days, or you are active military, that is in itself a pretty big deal, even if you're not an ex-felon. One thing I want to back up to, though, Evan, you earlier said Larry McMurtry facts, and
McMurtry, Lonesome Dove.
Oh, okay.
Oh, come on. Oh, he's great. He actually recently passed, I think. There's a lot of great, small town, I think Texas primarily, but, just kind of these small towns where the tensions simmer for decades, and highly recommended if our listeners out there haven't read Larry McMurtry. Highly recommend them.
Well, I appreciate the tip. I think I am older than you, but I did not get that cultural reference. So I appreciate you bringing it to everyone's attention.
Especially in our Texas office. They should double be reading him. It should be assigned.
That's not me, but I guess that's Christie's job now. So an even smaller town or smaller location, it seems, is this case from the 8th Circuit, and this property in the middle of nowhere, Iowa. Not to besmirch those who live in Jones County, Iowa, but the way the court describes this place, it's a pretty small location in rural Iowa, where a couple of guys just live across the street from each other and raise suspicions.
That's right. We're going to keep it rural. We're going to keep it with gun crimes, and we're going to keep it with facts that I think, have a lot hidden behind them that don't play into the federal case. But this involves happenings on John Lee Ralston's property. Now, he has about 9 acres, I believe, from the family. And it's one big lot, and it's split by Bear Creek Road. And these are all very evocative names, which is nice. At the south side of the property, there's a single-family house, and that's where John Lee Ralston lives. On the north side of the house, so about basically 8 to 9 acres away, there's a mobile home. And there's a Colton Varty who has been seen as residing or maybe just frequenting the home. And now it's kind of odd, and I think the police thought it was kind of odd, saying, all right, you own this property, and we get it, it's big, but there's this guy hanging out there, and this is a guy we have good reason to think has been stealing a lot of property in the area and reselling it. So the officers, I guess, do a little investigation and decide to get a warrant. And they get a warrant for the entire property. They get a warrant for the mobile home, but they also get a warrant for Ralston's residence. They get a warrant for the machine shed. They get 2 separate storage sheds with a separate address that's all on the same property. They're searching everything top and bottom. And so they go in and they don't find any stolen property, but they do find a firearm. And as we just discussed, this is the whole kit and caboodle to kind of keep it country. This is it. So they've got him. He's a prohibited person in possession of a firearm. And so it's actually the same statute as in our 10th Circuit case that they get him on. And he does the same thing. It said, look, if you've got me on this, you've got me. I'll plead guilty conditionally. And it's 37 months. So this is, this is not fun and games. This is multiple years in federal prison if you had a good reason to search the property. So when they say, the magistrate's looking at this case and says, okay, this warrant is way overbroad. You're looking at this one guy who's on the north side of the property. You want to search the entire lot, the house, not just, around the house or outside of the curtilage. We're talking inside the house. And you don't really establish any connection with the Varty. Now, I think we might think it's weird. Okay, well, why is he here? Why is he frequenting, even if I had a 9-acre lot, I would be inclined to know if somebody was just hanging out on the north side of my lot. But that's just a hunch, and that's not probable cause. And that's, you need to have something a little more spelled out than that. And the police never do it. They just say, well, he's been around here. We thought we saw one vehicle on the property on both sides that was seen at the scene of one of the crimes. We're not really quite sure. And the magistrate says this just isn't enough. So it goes up to the district court, and the district court says, well, it's probably not enough, but we think the good faith exception under Leon applies here. I think, well, look, your heart was in the right place. You had enough kind of circumstantial evidence. I mean, it's right. It's fuzzy. And they say, it's close enough. It's close enough. And the Court of Appeals, the 8th Circuit, looks at this and says, there's no good faith exception here. You guys are a free rocker. There's no way a reasonable officer would believe you had probable cause. You have no evidence of illegal activity at the defendant's home. You have no indication that any of the crimes that you're concerned with were involving this guy's home. And everything else you do is just talking about Ralston's prior convictions. Like it's basically a character assassination. Oh, he had all these felonies. Oh, he had this. Oh, he had that.
He was a shady guy.
Exactly. He was shady. But that's not good enough under Fourth Amendment jurisprudence. You can't just be a shady guy and expect.
Well, in this case, it's not enough.
In this case, it's not. That's a good point. It's
Speaking from
unfortunately not
here,
always
Evan,
the
you can't
case.
just be a shady guy.
You can't just be a shady. That you can't write an affidavit. He's pretty shady. That's not going to fly, at least in the 8th Circuit. And so I think the other thing I would flag for our listeners that I at least thought was interesting was, the distinction between a property and a residence. And I think a lot of people just say, well, it's your property. He's on your property. That's enough. I mean, that should be enough. And I think there might be a gut reaction to a casual reader of the case. Well, come on, it's his property. Like, of course he's got to know. And that's just simply not enough. And I think it's important, too, to remember, a lot of listeners, I'm going to go out on a limb and assume, are kind of more, city mice, we should say. And we don't think about having these big lots. And this comes up a lot in, some of our recent open fields work where, the concerns we have about homes and residences, a lot of times we're living in row homes or apartment buildings or things like that. What needs to be protected at the core is still the same, though. And there's just this assumption that, well, it's property, it's yours. Well, that might be true in an 800 square apartment, but that's not quite the case when it's a lot that you own. And I do think this kind of tension between property and residence and curtilage, the courts haven't fully sorted out. And I think especially in the open field concept, they're just wrong to think that, again, and I was almost thinking this, like maybe they should have just called the Wildlife Enforcement Division in Iowa, right? I mean, everything outside the curtilage is fair game. Just have these guys, we don't need anything. We don't even need a warrant. Just wander up and down, go right up to the edge, do a little peeking, maybe put some
for all we know, they did that.
That's true. So it doesn't show up in here. I mean, a little surprised, but maybe they'll get wind of this and start deputizing them. Put a couple cameras up there, like they did in our Tennessee case, and just let her rip and see what you can find. But in any event, the open fields doctrine did not come into play here. This was a old-fashioned warrant and good faith exception, and there was no good faith. The Eighth Circuit found, suppressed the evidence, and I have to imagine the case was dismissed after that.
I think it will be on
yes,
remand.
This was actually directed, so directed to vacate and grant his motion to suppress,
right.
And then I'm sure the feds will say, well, we're done here for now.
Well, that was a great summary, Evan. Full of lively language. I just also want to illustrate not only was Evan's summary exceptional, but this case is pretty exceptional. It's, I think, pretty rare for a court to come in and say, nope, you are completely unreasonable in relying on a magistrate's signed search warrant. And so, the facts of this case and the fact that it was, unreasonable to rely on this particular search warrant just kind of hides the exceptionalness of this particular case and the rarity. And kind of just to add a piece to rarity, I tried to really figure out how often motions to suppress are actually granted. And surprisingly, there wasn't a lot of system-wide data on motions to suppress. There were a couple of small studies and sample sizes. And from those, I kind of gleaned that only 1/3 maybe of motions to suppress are actually granted. But that's the tip of the iceberg, right? Because folks who have searches tend not to, and nothing is found, and they just kind of go along on their merry way, tend not to file a motion to suppress, obviously, because there's nothing to suppress. And so then if your Fourth Amendment rights are violated and they didn't find anything, you'd have to go out and hire an attorney out of your own pocket and sue the government. And as we know, the government has all sorts of defenses to kick your case out of court. So that's kind of a barrier. And then there is this other barrier that I discovered in just trying to figure out how many motions to suppress are actually granted versus denied. And there's some scholarship out there that criminal defense attorneys themselves, even if strategically it might be a good idea that the Fourth Amendment right was violated and you could get the evidence kicked out, they might not file a motion to suppress because it'll make the judge mad, and then their defendant will get a less favorable sentence, and there's some strategic questions to litigate there. And then defense attorneys also take into consideration their own career objectives in filing motions to suppress. So those complicating factors mean that it is difficult to find Fourth Amendment cases that give the Fourth Amendment right to be free from unreasonable searches some teeth.
Do you think, one other thing that jumped out, since you mentioned that this is kind of rare, the other weird thing here is this is one of those instances where the district court overrules. I mean, I'm not saying this happens super infrequently, but where they overruled the recommendation of the magistrate. Do you think that maybe at least gave the appellate court oh geez, this isn't a rubber stamp kind of situation? Or do you think it just looked at it, with a fresh set of eyes?
I used to think that most district court judges were just going to give R&Rs stamps. But I think in the last, I want to say 3 years, at least anecdotally, I have heard of a lot of folks experiencing district courts who overrule their magistrate opinions.
And Christie, by R&R, you mean the
report and recommendation from the
recommendation
magistrate judge.
that magistrate judge gives, but it's still, for a final judgment, it still needs to be signed off by the
Correct.
Article 3 district judge, right?
And
in federal
for
court.
those of us who don't do it all the time, a magistrate judge is not someone who has life tenure. They're hired for 8-year terms, I think, and then often on certain motions, they issue a report and recommendation. This is what I think you should rule, to a district judge. And then the parties here, the criminal defendant and the government, can file objections to that R&R, and then the district judge gets to decide, yes, I'm going to adopt this R&R, no, I'm going to change it in the final order, or no, I'm going to reject it wholesale. So there's kind of like a sliding scale of menu options for a district judge. And the idea is it takes some of the work off the district judge's plate, and kind of spreads it around, gives a recommendation, so they're not starting from scratch. But here, the district judge, didn't take that. And I think that we're seeing that more often. I don't know why. And, I could hazard guesses. Yeah. I'm sure you could hazard guesses. But I think we're seeing it more often. And I do think it's signaled to the Court of Appeals here that this is worth a second look.
Yeah, I definitely think that's a signal to the reviewing court that you might want to take a closer look here. Just like if the Supreme Court takes a case and the district court and the Court of Appeals took different views on the matter, that they're maybe going to be a little bit more sniffing around. I want to emphasize that the point that Christie made about this being such a rare type of case, and it's not, rational basis victory rare, it's something that we deal with a lot at IJ, but it is quite rare that you have a good faith exception to a warrant, that exception is not granted by the court. So that's where you have the police go to a judge. So in this case, this was a state court judge, and they say, "Hey, give us a warrant." The warrant is actually signed off on, and then they go and get the evidence. There's motion to suppress, and then they say, "You know what? Even though a judge signed off on that warrant, it was so terrible that we are not going to let the evidence in, and will grant the motion to suppress." And that is pretty rare, because it is a judge basically telling another judge that they didn't do their job correctly. And that exception has swallowed a lot of motions to suppress that otherwise would have been granted. And the job of the exclusionary rule in trying to stop bad behavior by police by the argument that, well, it's not the prophylactic that the exclusionary rule is supposed to be, because the police they were in good faith. They did everything right, and yet it was still signed off on. Well, they were the ones who put the warrant together. So I don't really see how that reasoning goes. Now, going back to what you said, Christie, on the studies, I'm actually really surprised that as high as a third of motion to suppress would be granted. I would have thought it's more like, 5% or something like that. But maybe it's something to do with the sample, or just the universe is different than you would expect because for the incentives that you were talking about. Is that right?
I'm not sure you can extrapolate really to the whole system, because as I said, the data is really small. There's no real systemic way of keeping track of a motion to suppress, and it often doesn't get back to the police department itself, which I think is another problem. So here you kind of have these two courts that are assuming that officers are going to pay attention to I'll call it the after show of their choices to search these locations. And if the police are busy with their day-to-day stuff and no one, is responsible for the chain of bringing the after show to the attention of these officers or the police departments, is there really any accountability? So there's kind of 2 points of there's not a lot of data tracking. So you got one-off things, because I was surprised too. I think it is lower, Anthony. I think it's lower where motion to suppresses are actually granted based on the a couple of occasions I've seen. And then there's no kind of feedback loop.
Right. And I think that it probably depends on the jurisdiction too. Like if it's federal court, if certain circuits, of course, definitely in state court where there's going to be a heck of a lot more of this litigation than in federal court, like we have here. It's going to heavily depend on the judges, and some states I can imagine in particular, not a lot of motions to suppress are probably granted.
Yeah, I don't know the actual statistics there, Anthony, but I do know that folks have quoted the statistics to me as sometimes something around above 95% of criminal indictments in the federal system end up in convictions.
Right.
Yeah.
Well, with plea bargaining, that's
right.
definitely absolutely true. And as you said earlier, plea bargaining has a lot to do with whether these motions are even filed in the first place, or how they're filed.
Yeah, you file them, and then the plea bargaining, that's kind of part of the negotiation, right? You say, all right, we won't litigate this. You knock off, this charge or reduce this or whatever. I could see a lot of them, merits or not, you just use it as a bargaining chip if you're in the defense to say, look, we could go through this or we could just reach a plea.
Well, I am going to grant a motion that you can now go your merry way. I know that Evan has a lot more editing to do before he can actually leave the office, but hopefully that will be coming soon. So a happy holidays to both of you and to all of our listeners. There will be a New Year's show next week for those of you listening to the podcast during our holiday break. And for the rest of you, look forward to the new year. But in the meantime, I hope that all of you get engaged.